Mr. Carl.
Thank you, my lord. Small item of housekeeping before I start my submissions. Some documents that were mentioned in submissions yesterday and not in the supplemental bundle. I propose to hand up a small clip of those, if I may. And I think Mr. Crowe also has a document as well.
Is it best if we take them all at the same time? Is that convenient, Mr. Crowe?
Absolutely. It's just it's not actually a document. It's just an article. Some of you may already be familiar with it. It's by Lionel Smith on fiduciary relationships. In light of some of the exchanges yesterday, we thought it might be useful to have that.
Thank you. My lords, if I might introduce those documents very briefly.
Yeah, just bear with me 1 moment. I'll find a home for them.
Yes. My lords, what there should be in that clip is firstly the 2 demand letters of 22nd of December 2009, followed by the June 2010 letter. Those 3 documents didn't come up to proof at trial, but they were mentioned yesterday, so I brought them along. The last document in that clip is an email and accompanying attachment from Falak Yusuf. This is Mr. Yusuf returning to Miss Caulfield on the 1st of August 2014 a marked up, hand annotated draft of the Statement of Affairs, or at least the material parts of it. The thing that's particularly relevant in light of some exchanges with my Lord Justice Arnold yesterday is the final page of that, where the error, so-called, in the initial draft of the Statement of Affairs is corrected by Mr. Yusuf. So it was formerly thought that the company owned the whole of JJW Guernsey and JJW Guernsey owned 11.2% of JJW Inc. In fact, it was the other way round. And Mr. Yusuf has hand annotated that on that final page, and one sees that this is indeed a pro rata calculation of the value of the shares, and that is the estimated to realised value that the Sheikh puts his name to. In terms of the judge's findings on the Sheikh's knowledge of all this,
where do you suggest, if anywhere, that we put these in the bundles?
I would suggest it just simply at the end of the supplemental bundle, my lord. If I could, for your lordship's note, the judge's discussion of the Statement of Affairs in the context of Mr. Yusuf's work on it is at paragraphs 239 to 241 at page 165 of the core bundle. And in short, she finds it's been carefully done and the Sheikh knows all about it. Ground one, then, my lords. I should like to start by summarising the Liquidators' response to the Sheikh's appeal on ground one in 3 points. The Sheikh says that section 175(1)(b) of the Insolvency Act 2003 is intended to exclude the general law on fiduciary liability, which means that those principles can't apply to a de jure director post-liquidation. And we say that's simply wrong. The same principles apply in BVI as under English law, and directors, de jure directors, certainly don't enjoy a carve-out from those principles. The general law on fiduciaries still applies. that is consistent with what the Sheikh's expert said below. That's at those exchanges are at page 125 of the supplemental bundle, on page 63 of the extract from the transcripts there.
Sorry, page 125 of the supplemental bundle.
Yes, my lords. In fact, the exchange starts at page 62 on the bottom left-hand corner of page 125.
Save me coming back to it. Could you start at page 61, line 10?
Yep. So Mr. Lowe is asked about section 175 1b at line 10, and he says they don't have any functions, so it's definitely an oxymoron. And he's asked about a wider meaning of required in that section. But then he's asked, and the point I'm making now is the exchanges that commence at line 17 of page 62, where he's asked about post-liquidation dealings. And Mr. Lowe answers at line 25 of page 62, I don't know. That's obviously, I think, with respect, Mr. Curl, a matter for her ladyship. And then he gives an example that I don't need to read out. And then at line 8 he says, but I don't know enough about the facts. I wouldn't like to express an opinion on whether that's the case. And I would have thought with great respect that that's a matter for her, that her ladyship is best placed to deal with. And then I ask, all right, applying the same common law principles and authorities in this jurisdiction, Mr. Lowe says, exactly. And he says that he and our expert are ad idem on the fact that almost everywhere English common law is applied.
Where does that get you? I mean, obviously, ordinarily, de jure directors owe fiduciary duties. As I understand it, the prevailing view in English law is that when a compulsory winding up order is made, you stop being a director.
Yes.
Therefore, presumably, you stop having fiduciary duties as a director. Here we find that BVI law is different. You remain in office. The question is, to what extent, if any, you retain fiduciary duties? Does anything that Mr. Lowe has said here really help on that?
In my submission, it does, because he is accepting that the general law of fiduciaries, as set out in English law, applies. And so the submissions that I'm going to go on to make in a moment or two about Category 1 constructive trustees, of which company directors are a species, all applies.
So we're taking Mr. Lowe on the basis of saying that common law principles apply, as saying that someone who remains de jure director but has had all his powers, functions and duties stripped from him is still subject to fiduciary duties. Did he really say that?
No, I don't suggest that Mr. Lowe did say that. My lord, my submission is that this is in answer to the Sheikh's submission yesterday, that section 175 1b of the Insolvency Act 2003 essentially is a complete code. And what I'm saying, what I'm submitting, and what I submit Mr. Lowe accepted, is that the general law, it's not an exhaustive code, the general law still applies. And so the submissions that I'm going to come on to make about Category 1 constructive trustees, in circumstances where a director, albeit stripped of his powers, has arrogated to himself the power to deal with the company's property, remains a constructive trustee in the first category.
There are two, I mean, in certain respects there's not much difference, I think, between you and Mr. Crowe. The questioning here, for example, at the bottom of page bottom of page 62 of the internal numbering, and possibly your summary of Mr. Lowe's evidence that Mr. Crowe asked us to look at page 61 between lines 10 and 16 talks about a director who loses his powers subject to authorization by the liquidator because of section 175(1)(b), but who still has custody or control of the property after liquidation. And there's an interesting question about control, but that's the premise upon which you put the question at the bottom of page 62. And I didn't understand Mr. Crowe to dispute the fact that if a director has custody of company property after the guillotine comes down under section 175(1)(b), he would still be under some form of fiduciary obligation in relation to his dealings with that property, that particular property that he had held on to.
Yes.
In other words, he has to hand it over.
Yes.
Now, I didn't understand Mr. Crowe to sort of dispute that, and he'll correct me if I'm wrong. He doesn't. Thank you. But that's a very specific type of situation and possibly very short-lived. The difference between you, I think, is where there is a longer period which elapses, as it did indeed in this case, and where it doesn't relate to specific items of property which in some way the director still has custody or control of. Because Mr. Crowe says, except in a situation where the liquidator authorises the director who's still in office to do something, in which case, again, I think Mr. Crowe accepts that the director would be under fiduciary obligations in relation to those authorised exercises of power. He says that no continuing fiduciary duties because no power is capable of being exercised. That's the target I think you need to aim at. But then you have an additional point, which I think is also inherent in what you were saying, which I think does need to be separated out, which picks up the points my Lord Justice Newey made to Mr. Crowe yesterday, which is, the stranger who comes and takes on the mantle of a director or liquidator post-liquidation, why should somebody who remains in office as a director be in any different position?
Well, exactly. That's exactly it.
But these are two different things, and I know in front of the judge, you, according to the judgment said you didn't really distinguish between the two. You treated the two as the same, and I'm putting to you that actually I think you may need to distinguish between the two.
If I may, my lord, the distinction between Mr. Crowe and myself is, as I understand it, Mr. Crowe accepts that when a director has custody or control, then he's liable as a fiduciary. But he considers custody to be literal possession in the way of a traditional trustee, and he considers control to be authorised control. So, in other words, within the scheme of the statute, and that kind of control, Mr. Crowe submits, comes to an end on liquidation. And what we say is that where someone arrogates to themselves the power to deal, they are liable, as my lord just put it, as a stranger would be if they assume to do that kind of dealing. And the judge had in mind. No, I'll park that point, come back to that. But I'll move on to the second of my summary points, my lord, which is that it really leads on from those exchanges, my lords, which is the Sheikh's submissions on ground one are really just a very complicated way of identifying the inevitable difference between a traditional trustee and a company director, namely that a traditional trustee typically has the assets vested in them, legal title, whereas in the case of a company director, the company remains the legal and beneficial owner of its property. Nonetheless, the director is treated for the purposes of the corpus of trust law dating back hundreds of years as if they had possession, notwithstanding that it's the company that has the literal possession in the sense of legal title.
Okay, I'm not sure I agree with that. I think company directors are treated as fiduciaries because they have powers over somebody else's property.
I'll endeavour to make good that submission in a few moments, my lord, by reference to Burnham and Fielding in the Supreme Court. But whether or not it's properly to be characterised as treated as having possession, or whether it's to be properly characterised as having powers over someone's property, it's really all roads lead to Rome. It's to all intents and purposes the same. It's a question of dealing with somebody else's property in the name of that other person or on behalf of that other person. That's the point as I characterise it, my lord. The third and final of my summary points is that and again this leads on from an observation that your lordship made a moment or two ago. The Sheikh's case, we say, depends on the proposition that the settled principle forces the conclusion that a de jure director is better placed to avoid liability in that capacity if the director waits until after the commencement of winding up before stealing his company's assets, compared with the position before winding up. And we say that's clearly wrong. The fact that the director remains in office Dutch ought not to put them and cannot put them in a better position for stealing assets than they were in prior to the commencement of liquidation.
Yeah, but that way of putting the case assumes what you're trying to prove, namely that they've stolen the company's assets.
Well, my lord, the facts which are unappealed from are that the company's assets were transferred away on the 23rd of June 2016. Sorry, were transferred away on the 8th of March 2016. They were then transferred on again, such that they cannot now be recovered. Mr. Crowe said in
So my lord's point to you, I think you're not picking up on respect. You don't assist the analysis, which is very technical, by using the word steal.
I see,
Okay.
my lord. All right.
You because
You can only steal tangible property which belongs to someone else.
yeah, and there may be a real difference between a stranger, a third party, who simply comes in. Well, as you say, but you can't steal intangible property. But the critical element may be the clothing of the assumption by the person of the persona of the director or the liquidator, whoever it is who is actually empowered to deal, rather than just, as it were, in your head, mentally thinking about somebody breaking and entering and doing away with tangible assets, which is the vision you get when you talk about stealing.
All right. Well, I'll withdraw the reference to stealing then, and I'll
Right.
Now,
Yes, that's helpful. And what I think would be even more helpful is if you could clarify for us the nature of your case as to precisely the acts that were alleged to constitute the breach of FI's usury duty. Looking at the judgment again overnight, I found what seemed to me to be a helpful paragraph, which is paragraph 450. This is page 221 in the core bundle. And what the judge says in paragraph 450 is that she must determine whether on balance the liquidators are satisfied with that, as they allege in the POC, and then I take that this is a direct quote from your particular claim, the Sheikh or some persons acting on the Sheikh's instruction completed the share transfer forms and caused registration of the 891k shares to be transferred or purportedly transferred to JJW Guernsey on 8th March 2016, and so on and so forth. Now, that seems to me to be helpful because, as I understand it, what that pleading encompasses is what, to my mind, are two distinct acts. The first act is the act of the Sheikh in signing the share transfer forms that you showed us yesterday, tabs 13 and 14 in the supplementary bundle, pursuant to the resolution that he also signed. And it appears that the resolution we know from the judge's finding of fact was signed on the 29th of February 2016. We assume the share transfer forms were signed shortly thereafter. Now, so far as that aspect of the matter is concerned, I'm still troubled by the fact that there is a clear, explicit and unappealed finding of the judge that that was void and of no effect. And I still struggle with how you can say that an act which is void and of no effect can constitute a breach of fiduciary duty. However, there is then a second dimension to your case, as I see it at the moment, which is what we were talking about also yesterday, which is the act of causing registration. Because what we see, as we looked at yesterday, particularly from paragraph 518, the judge has found that legal title was transferred and then to firstly to JJW Guernsey, and secondly, JJW Guernsey then transferred on to MBI International Holdings. And the first, what enabled that to happen was the registration on the 8th of March 2016. So, although there's a purported finding of the judge elsewhere that that was also void, it seems clear from 518 that she can't amend that, because otherwise there wouldn't have been legal title being conferred by registration. So, the question therefore I think is this: did the judge find that, as you had alleged in your particulars of claim, and as she quotes in paragraph 450, that the act of causing the registration was a breach of his fiduciary duty? Because if she did, then I think everything falls into place. But I'm not, that's the bit I'm struggling to find, because she poses the question to herself very clearly at 450. But I'm struggling to find it where it's answered specifically with regard to causing registration on the 8th of March.
Yes, my lord, the finding that the judge made that is at my fingertips on that subject is that the judge found that the Sheikh did cause the registration of the 891,000 shares, and that's at 554 on paragraph 554 on page 227. And I might just turn my back a moment. That's signing the share. Oh, right. Yes, so the judge finds at paragraph
454, right.
Yes, it's 454, the final sentence of that, where she finds that it was the Sheikh that caused the registration. So there's the Sheikh's submission on this appeal that was an act of JJW Inc. can't stand against that unappealed finding of fact.
Well, I think there's no contradiction.
Sorry, it's the beginning of 456, isn't it?
Yes, that is the finding that he didn't act honestly or in good faith in signing the share transfer forms and in causing the transfer of the 891,000 shares.
Pursuant to the resolution being a resolution of
JJW Inc.
Yeah, well, see, that's not signing the shares. Sorry, signing the transfers, and in that sense, causing the transfer. Because the signature of the transfer was void, with no effect. Whereas registration, if he caused that, that may be different. And so, as I understand it, what you're inviting us to do is to read, when she says causing the transfer on the 8th of March, what she means there is causing the registration, which is what you pleaded.
Yes, otherwise it would be, it would simply be saying the same thing in different words to what she said in the first half of that sentence, which is having signed the share transfer forms, he didn't act honestly or in good faith. And then she's clearly saying something different in the words after the and, which is in causing the transfer of the 891,000 shares. So that can only be the registration, I would respectfully submit.
So I had understood this, that paragraph 450 that my Lord drew your attention to is a reference to paragraph 53A of the points of claim. Is that right?
That sounds right. I'll have to turn up
Well, if you,
points of claim.
and it's because, as I understood it, my Lord's question to you, where does the judge answer the question she posed for herself at 450? I thought the answer is at 456 and at the first sentence of 457.
Yes. Oh well. Yes. In light of the first sentence of 457, it must be. It must be the case at 53A. And that is at page 293 of the core bundle.
Yeah, well, that seems to be a fair summary of.
Yes. So that's a pleading of breach, indeed a dishonest breach, in relation both to completing the share transfer forms and in causing the registration of the shares. So, in my respectful submission, that the findings of the judge at 454, 456, and 457 are a finding of breach in relation to both those things.
Can we leave on one side the share transfer forms for a moment? Think just about the registration. In that respect, the Sheikh purports to act as a director of JJW Inc. So suppose there had been no share registration forms, or indeed the share registration forms are completed later. At the stage when he signs the resolution and causes the registration, well, at any rate, when he signs the resolution, he hasn't purported to act as a director of our company. So why is he in breach of fiduciary duty to our company?
Well, I'm not sure I make any case either way on that, because that isn't what happened. It was the share transfer forms were an ingredient of the registration, because Maples prepared that February 2016 resolution, and the judge made a finding about that, I believe. And in that resolution, there is extensive cross-reference to not only to the share transfer forms, but also to the fact that the Sheikh had ascertained, as it puts it, that they'd been signed on the 6th of July 2010. So it's the registration was facilitated directly by his having signed the share transfer forms in the capacity of a director of the company.
But I'm a bit puzzled by this because, as I keep on pointing out, his signature of the share transfer forms was void and no effect. So you have to ignore those. However, that's not the end of your case. And it comes back to this question of which you've already raised, and rightly so, which is why should he be in a better position than a stranger? So if a stranger comes along and somehow achieves registration of the shares to JJW Guernsey on 8th of March, then the stranger would be intermeddling, and you say the Sheikh isn't in any better position. But that's got nothing to do with, or it doesn't depend upon, the void signature of the transfer forms. Is that how you put the case?
Well, in a practical sense, it did, because Maples wouldn't have cooperated with or acted on his instructions without the share transfer forms from a director.
Right. So how do you get around the fact that they're void and no effect?
It's because the shares have ended up being placed beyond reach. We cannot, as Mr. Crowe said a number of times yesterday, the shares are not going to be returned. The transfer on 23rd of June 2017 to MBI International Holdings on a transaction that we know nothing about, and we can't know anything about because the Sheikh hasn't told us, that put the shares permanently beyond reach. So, as I submitted yesterday, for all we know, MBI International Holdings might have been a bona fide purchase of value without notice. We simply don't know.
But what you're saying, I think what you have to say is, look, the legal title, which I think is what my law's putting to you, the legal title to the shares, we know, was transferred, in inverted commas, when the register of Inc. was changed, was altered. And it was the combination of the signature of the share transfers and their acceptance pursuant to the February 2016 resolution by the board or by the sole director of Inc. that put the legal title to the shares into the hands of JJW Guernsey and took them out of the hands of the company, the legal name of the company. Sorry, I should say name rather than hands. Right?
Yes, yes.
So, even though the transfer, the instrument of transfer was void, because it was done without authority, the effect of the twin falsification of the share transfer and its acting upon by the board of JJW Guernsey was to take the legal title to the shares out of the company's name, which facilitated the further on transfer of the legal title subsequently. Now I think you say the beneficial interest in the shares is and always has been in the company, because there has been no valid transfer of beneficial ownership out of the company.
Beneficial ownership remained in the company in the sense necessary to maintain a knowing receipt claim, for instance, that it's always inevitable that the company retains its proprietary base.
To that extent, the disposition purportedly affected by the share transfer was void.
My lord, yes, but there's nothing unusual about that.
Don't always kick against the gift horse.
Right.
Okay.
Yeah. Well, yes. Yes. So yes, I do agree with that analysis, my lord. Yes.
Don't always pat it on the head either.
Right.
Just don't assume this is a hostile set of questions.
No.
I'm just trying to sort of ventilate an analysis which seeks to tie my lord's concern about the voidness of the transfer with the apparent valid legal movement of legal title, because that's what I think.
Yes.
I certainly, for one, need help.
I agree with your lordship on that. In any case where property is misappropriated from a company and is received on a breach of fiduciary duty and is received by someone with knowledge of the antecedent breach, the beneficial right remains in the claimant.
I have to say, I don't think it matters for this case, but if it did matter, I'd want authority on that.
Well, I mean, buyers in the Supreme Court in the last few weeks.
Buyers says that if someone purports to transfer property and legal title is indeed transferred, the beneficial title remains with the transferor. I don't think it does.
It says that a persisting proprietary base in the claimant is essential in order to maintain.
It says a persistent proprietary base is essential, but it doesn't say when that will exist.
Well, it might be overreached later on if it comes into the hands of a bona fide purchaser for value without notice. But if one,
I really don't think. I don't at the moment see why any of this matters for this case. But it isn't obvious to me that whenever a transfer is misguidedly registered in the share register, with the result that legal title passes, the beneficial title remains with the transferor. But I don't think it really matters.
Well, in that case,
But if it does matter, I'd like authority on it, please.
I don't suggest that it does matter, because the ingredients of my case are breach of fiduciary duty, legal title moves to JJW Guernsey, and then the shares are put permanently beyond reach.
And just as to the stage one, the role of the share transfer, it shouldn't have been seen as having legal effect, but it still existed. It was a piece of paper.
Absolutely,
It didn't.
my lord, yes.
It didn't disappear in any way. And you say that was crucial to how the registration came to be affected, not least because Maples wouldn't have affected the registration without a share transfer.
Exactly, my lord. Yes, precisely. The proposition that this transaction did not happen, as the Sheikh puts it in his skeleton argument, is really flies in the face of reality when we are without the shares right up to the present day. We don't know where they've been since the 26th of March 2020.
Well, you're without legal title to the shares, that is clear.
It's clear from submissions yesterday and the practical situation on the ground that the shares aren't coming back.
Well, the legal title to the shares is not vested in the company at the moment, and hasn't been since the
8th of March,
2016. That we are all, I suspect, clear about.
Quite, my lord. Yes.
Can I just, there's one other point, my Lord Justice Newey put to you, and that's the fact that the Sheikh wore a different hat, namely as a director of Inc., when he approved the alteration to the register of members of Inc., doesn't at the moment seem to me to be inconsistent with him having breached fiduciary duties to the company, because simply because that was the hat he was wearing when he did what he did. I mean, if a director diverts a corporate opportunity by causing his creature company to enter into the contract which should have gone to the company, the fact that he's wearing the directorial hat of the creature company when he signs the contract doesn't mean it isn't a breach of his duty to the
Quite so.
company.
Well, that's the vice of it, really.
So that I don't find it problematic that for your case that at the moment that the act of procuring the registration was done in the capacity as director of Inc. If the person was under a simultaneous duty to the company not to do it.
Quite, my lord. Yes.
That I just wanted to sort of say that, so, well, not least because it's on the transcript in case I forget it.
Right.
But that's certainly the moment is where I would be on that point.
Well, very good, my lord. In that case, I won't.
Just show my hand, but
test your patience on that point.
Not speaking for others, but
yes. Well, my lord, I'll move on then after those three introductory points that I had hoped would rather like Mr. Crowe yesterday, I hope would take 10 minutes. But I'll move on now to, I'd like to say one or two things about Williams and Central Bank of Nigeria on the two categories of constructive trustee. This is at page 1008 of the authorities bundle. The particular passage I should like to go to is at page 1016.
Do you have a tab number?
Sorry, my lord, if I might just have a moment on that. It's tab 48, my lord. The passage here from Lord Sumption's judgment at paragraph 9 is really key on this. If I could respectfully invite your lordships I'm sure you've read it many times before. If I can invite your lordships to read paragraph 9 to yourselves. So one or two points I should like to draw out of that, my lord. The distinction between Category 1 and Category 2 constructive trustees is that Category 1 constructive trustees includes people who have lawfully assumed fiduciary obligations in relation to trust property, but without formal appointment or implied from intention. The reference there to trustee de son tort, it doesn't say anything about the trustee de son tort taking legal title. In fact, it talks about assuming to act in the administration of trusts, and that's really the vice of it. We submit that plainly this will include people who hold themselves out as fiduciaries for the purpose of transacting business on behalf of another with trust assets. And in our submission, it's probable that quite a lot less than a positive holding out will do, but a positive holding out will certainly do it. And of course, Lord Sumption there makes clear that company directors are in a similar position. And Lord Sumption would, I'm sure, have agreed with the proposition that that will include de facto and shadow directors, where people clothe themselves with the authority of a director for the purpose of transacting business.
I think, with respect, I mean, let's not get into this because this is not a case of shadow directors. I do have a doubt that that's what a shadow director does. A de facto director, I perfectly well understand, is somebody who presumes to act as a director. And de facto is a more modern way of expressing that. A shadow director, by definition, is somebody who doesn't presume themselves to act as a director, but he gives instructions to the directors on which instructions they are accustomed to act. The clue is in the name, shadow. He remains in the shadow. He doesn't. That's exactly. So the shadow director doesn't want to be perceived to be a director. Doesn't take on the mantle of a director. He just is the puppeteer, for want of a better expression, who pulls the strings of the directors. So let's not get distracted, but I wouldn't put shadow directors necessarily into the same category as a de facto director.
All right. My lord, I won't labour that point, but I'll just flag up.
It's unnecessary for this case.
And I think, in fact, it's now governed by statute to a great extent.
All right. I'll strike my reference to shadow directors then, and we'll say that we would say that people who clothe themselves as in the manner of a de facto director with the status of a director for the purpose of transacting business will be within this Category 1 constructive trust. And what we say really, what it really boils down to, our submission on ground 1, is that a person cannot simultaneously assert their status as a director for the purpose of transacting business on behalf of the company and simultaneously repudiate that status when it comes to liability. That's probably our position on ground 1 reduced to a sentence, my lords. And lastly on this paragraph, the last 3 lines on page 1016, it makes clear that a constructive trustee in the second category, i.e. Someone liable, someone fixed with ancillary liability, such as a knowing recipient or a dishonest assistant, they, in the words of Lord Sumption, never assumed and never intended to assume the status of a trustee. That's obviously quite different from the Sheikh, and that, in my submission, is an answer to the Sheikh's submission on this appeal, that if he was anything, he was a dishonest assistant. Well, he's not, because he's not a stranger to the assets in the way of someone with ancillary liability, and moreover, there isn't any candidate for the antecedent breach of fiduciary duty.
I have to say, I'm not sure that any of this helps all that much, because we know there are different categories, but that's not what we're really concerned with. We're concerned with when someone will have the duty by virtue of a fiduciary relationship or by virtue of intermeddling, if that's different. And plainly, if such a liability exists, it doesn't actually matter to try to categorise it. I dare say it's a Category 1 case, but I'm not sure. That isn't the real question.
The reason it is, in my submission, it's important to bring it within Category 1 is because if the shake isn't within Category 1, then it's hard to identify the breach of fiduciary duty that is required.
If he isn't within
in order to
Category
make
1,
that case
then he's home free, because, as you say, there's no dishonest assistance. But that doesn't mean he is within Category 1.
We say he's within Category 1 because he assumed to act by a transaction that preceded the wrongdoing. Namely, he was appointed as a de jure director, and he was still a de jure director when he did these acts. And
so it's crucial, is it, that he had already been a de jure director? So intermeddling doesn't provide a sufficient basis. I mean, so the stranger who pretends to be a director is all right because they haven't got the preceding status.
No, they are. The analysis is slightly different, as my Lord Justice Snowden identified earlier. That between his liability strictly as a de jure director and an intermeddler who pretended to be a director, and we pleaded this out fairly compendiously at paragraph 66 to 68 of the points of claim with these sorts of thoughts in mind, and our submission really comes down to the proposition that the Sheikh was a de jure director, so he can't possibly be in a better position than an intermeddler would be, someone who clothed themselves with the status for this transaction.
You say take my Lord's example of yesterday, the complete stranger, the complete intermeddler, who passed himself off as a director, who impersonated a director, or impersonated a liquidator, let's say, impersonated a liquidator,
yes,
would be liable because they have assumed, they have pretended to be somebody with fiduciary responsibilities, and they are accountable as if they had the authority which they assumed.
Exactly.
And I'm just reading from paragraph 54 of this judgment, actually. But and you say, well, somebody who actually was a director can't be in any better position than the intermeddler.
Yes.
But your proposition doesn't depend on that. Well, sorry. I mean, you have two limbs, you have two strings to your bow, but certainly on the second point, you say somebody in that position can't be in any better position than the intermeddler.
Exactly, my lord. Your lordship puts it far better than I do. That is our case. Yes.
Yeah. And then you still have to deal with the restriction which appears in some of the authorities, that the liability of an intermeddler is restricted to property which they have received.
Precisely, my lord.
And whether that is in fact a valid conceptual limitation, or whether in truth they are simply accountable as if they had the authority which has been assumed.
That's right, my lord. And that's the very next point that I'm going to make by reference to Burnham and Fielding. Just before I do, Mr. Crowe didn't advance in submissions yesterday that the Category 1, Category 2 distinction is restricted to cases of limitation. That was argued at trial. I assume that's no longer persisted with, but if there's to be any suggestion that it is restricted to cases of limitation, I submit that it's not, and that is clear from not least the organisation of Lord Sumption's judgment in Williams, where he identifies the two categories of constructive trust before then going on to apply that principled distinction to.
He relies on Seligor and Paragon,
which isn't a limitation case, precisely, my lord. Yes. And lest there was any doubt left at all, the Supreme Court in Byers, Lord Briggs in the majority made clear that it is a general principle not limited to limitation, we say, and that's paragraph 93 of Byers, which I don't need to take the lordships to. That's just for the avoidance of any doubt. That's our position. So I should now like to move on to Burnden and Fielding, which is important, we say, because it deals with this theory that an intermeddler or a director post liquidation can only be liable to the extent that they take legal title, what might be called possession, although I appreciate not literally possession in the case of shares, but legal title to assets. And as I said in my opening summary, we say that the Shakes case is really just a restatement of the inevitable distinction between company directors and traditional trustees, and the submissions in the Shakes skeleton on the what they describe as the rule in JJ Harrison. That's really just making that point in a complicated way, which is that a company director doesn't take legal title in the way of a traditional trustee. So Burnden and Fielding then, at page 1190 of the authorities bundle, and that is tab 54, my lords. Now this claim, as your lordships I'm sure will recall, was about the transfer by the claimant company of a share, which was in a company called Vital, to the claimant's holding company, which was defined as BHUH, purportedly as a distribution in specie. It was alleged that that was an unlawful distribution. The defendants were the directors of the claimant at the time of that distribution, and also the majority shareholders of BHUH. The company claimed against them for breach of fiduciary duties. Defendants argued limitation, contending that the claimant couldn't get through the gateway under section 21(1)(b of the Limitation Act 1980, that being that trust property had previously been in the possession of the defendants or previously received by them and converted to their use. If I could invite your lordships to turn, please, to page 1197, paragraph 11. Again, the first two sentences of this paragraph 11 make clear that the relevant distinction that's being drawn between the two classes of constructive trustee is of general application, which then goes on to drive the conclusion on limitation. And there was some controversy yesterday about the use of the word stewardship, but in the second sentence here, this perhaps is where I got it from, it says this is because they are entrusted, they being company directors, are entrusted with the stewardship of the company's property and owe fiduciary duties to the company in respect of that stewardship. Then it gives all the usual examples that one would expect to see. The argument was run over the page at 1198. The argument was run at 15.3 towards the bottom of that page. Mr. Chivers, KC, submitted that it was wrong in principle to equate control of a company with possession of its assets, save perhaps where the company was a pure nominee. And we see the analysis over the page at 1199, paragraphs 18 and 19. If in the interest of time, perhaps I should invite your lordships to read paragraphs 18 and 19.
Yeah, I'll do that.
there are a couple of points, my lord, I should like to draw out of those paragraphs. First of all, paragraph 18, in the second sentence, it says an express trustee, such as a trustee of a strict settlement, might or might not from time to time, or indeed at all, be in possession or receipt of the trust property. Well, that would answer, even on its own terms, the Sheikh's argument on this appeal. But then they go on at paragraph 19 to contrast the way of a traditional trustee with that of a company director. And it says, by contrast, in the context of company property, directors are to be treated as being in possession of the trust property from the outset. So it's a reality of the director's office that they don't take title to these assets. And the Sheikh's case comes down to the proposition that inevitable feature of a company director's office makes all the difference post-liquidation, when it doesn't make any relevant difference to liability before liquidation. And we submit that that's simply wrong. And lastly, on this authority, could I invite your lordships on page 1200 to read paragraphs 21 and 22, please? The point I should like to emphasise from those paragraphs, my lord, is that an unlawful distribution of a share, i.e. a void distribution of a share, nonetheless amounts to a conversion where it's taken by a company under the control of the defendants in defiance of the company's rights of ownership.
Sorry, he says it's unlawful, but where does he say it was void?
Well, unlawful distributions, my lord, I submit are void. That's in their nature. They're unlawful. They're treated as unlawful and void. Not
well, they may be unlawful, but not necessarily void. One thing doesn't necessarily follow from the other, does it?
All right, my lord. In the interest of time, I'll come back to that at 2 o'clock, if I may. Even if I'm wrong about that, my lord, it doesn't make any material difference to the submission I'm making, which is that this provides a complete answer in my submission to the Sheikh's case, that the fact that the Sheikh in this case didn't take personal title, legal title, to the converted share somehow makes a difference because the company was in liquidation. That's an answer to that. Because I submit, my lords, that the only factual distinction of relevance between the Burnden case and the instant case is that for some of the time, one of the companies over which the Sheikh was in control was in liquidation, and my learned friends will say, "Oh, well, that means he wasn't in control of it." But that is a distinction that cannot, according to these principles on Category 1 constructive trustees, cannot make a relevant difference.
Can you convert a share?
Well, that certainly seems.
Or can you convert it for this is all in the context of understanding Section 21 of the Limitation Act, which uses the word converted to his use. I mean, is Lord Briggs saying that he's using conversion in the sense in which it must be understood in Section 21 of the Limitation Act, or is he stating a general proposition? Because if you can convert a share as a piece of intangible property, then think I've missed something somewhere along the line.
I have to say,
my lord.
my own understanding is that your problem arises from the fact that you cannot convert a share as such. You could convert a share certificate,
Correct.
but you can't convert a share as a matter of tort.
Has so held, hasn't it?
But it may be that conversion is used in a more, is read more broadly in section 21, or maybe Lord Briggs is, in a sense, section 20. I think the whole point that he's making, I have to say, this is the case which I actually was counsel in the case at first instance, so I should know what it all is about, but I've long since forgotten, wiped it from my memory. But I thought this was all in the context of reading section 21 in order to fit it to company directors who are not trustees in the strict sense. Because, as you rightly say, they don't have legal title vested in them in the way that trustees in the strict sense do. And it may be that conversion is being read in that in a similar vein.
Well, two answers to that, my lord. Your lordship may well be right, but this isn't a pleading of conversion. So, to the extent that it's using conversion as a term of art, then it doesn't affect our case. But separately, the authorities that I'm going to touch on, if I have time, when dealing with ground 2 about assessment of damages where shares have been misappropriated, that would seem to suggest that misappropriations of shares have at least been treated as conversion for purposes of damages. If I might add a third point to that, my lords, I entirely agree with my Lord Justice Snowden's observation that this is about fitting company directors into section 21. I entirely accept that. But as with the Williams case, the propositions about the nature of the deemed possession of company directors is of general application, and it's that general principle that is being applied to the particular circumstances of limitation. These aren't fictions that are adopted solely for the purposes of limitation. And the passage that I invited your lordships to read at paragraphs 18 and 19 of Burnden is just that kind of exposition of general principle, not restricted to limitation.
Yeah, I think you get a degree of the sense of the argument from paragraph 13. In fact,
in the interest of time, I'm not going to take the court to buyers, but there is interesting discussion in there, making clear that it's in the nature of companies not to be like traditional trusts for the purposes of breach of fiduciary duty and consequent knowing receipt. And if your lordships note, paragraphs 56, 58 and 60 to 61 at pages 1522 to 1524 are instructive. On that point, it was suggested in submissions yesterday that the judge had based her decision on custody and control of the sheikh, but if one looks at the preceding paragraphs from the judgment, it's clear that the judge had well in mind that a company director doesn't take legal title to assets, and that ought not, in accordance with the case I'm submitting to your lordships now, ought not to make a difference. And the judge, in fact, said at paragraph 381, core bundle 205, she suggested that the sheikh's focus on this point was boxing at shadows, as the judge put it, and we say that's exactly right.
Sorry, 381. What's that?
Paragraph 381, my lord,
Yep.
at core bundle 205.
Yes.
On JJ Harrison, I won't take the call to JJ Harrison, but I'll mention it again because it's so prominent in the shake skeleton argument, the so-called JJ Harrison rule. One searches that judgment in vain in my submission for any suggestion that Lord Justice Chadwick is creating an exclusionary rule or is setting out an exhaustive or exclusive statement of a director's liability. We entirely accept that if a director transfers or an ex-director transfers property to themselves, then yes, they will be liable. But there's nothing in that judgment to say that in a circumstance such as the instant case, that a director won't be similarly liable.
So is this right? You take my lord's intermeddler, who pretends to be the liquidator of the company, and by pretending to be the liquidator procures that an asset of the company in liquidation is transferred to a third party. Are you addressing the point about whether the intermeddler in that situation escapes liability completely because there's no property transferred to them, or whether they are liable in the same way that an express trustee would be for simply misapplying assets of the company?
Yes, the latter, my lord. That's the submission.
So, as I understand it, the authorities that talk about somebody who clothes themselves in the persona of a fiduciary being treated as if they were a fiduciary for the purposes of remedies, equitable remedies and liabilities. That is the basis for the liability, rather than any narrow construct based upon receipt of property.
Exactly, my lord. Yes, exactly.
Right.
Exactly. Perhaps I could show you what Lord Collins said in the paycheck case to sort of take that a little bit further. But that is our case, my lord. If I could invite your lordships to turn, please, to page 715 of the authorities bundle.
Do you know which tab that is?
Yeah. Well, I'll soon find out. It is tab 38, my lords. So this is the case about de facto directors, my lord, and Lord Collins is treating de facto directors as analogous to executors de son tort, and he refers to Gibson and Barton as the first case where that analogy was drawn. And if I could invite your lordships to read the extract from Gibson and Barton, the first 10 lines of that, ending between E and F.
Sorry, which page are we on?
Sorry, 715, my lords. So, my lords, it's the submission is that that a de facto director is analogous to an executor de son tort, and the extract from Gibson and Barton, the first, I think, 10 lines of that, down to where the words "director in your own wrong" appear between E and F. And then, my lords, just by letter G.
I don't know if your lordship stopped reading, but the passage between F and G is worth taking into account.
Shall we read the whole of the extract from?
Yes, splendid. Thank you, my lords. I'm just mindful of the time. I'm not trying to jump over things that aren't helpful to me, but yes, it's just a question of time. So the mischief that's in view here is, as it says by letter G, taking on himself the management of the company. He has of his own authority done an act which was to be done only by the directors. That's the mischief in view in holding people who aren't directors liable as if they were directors. It's got nothing to do with possession or legal title. And yes, my lord, sorry.
In one sense, I wonder whether we're really in this territory. This was a case where there was a question of whether the person was liable for failing to do something. For that purpose, he had to be treated as a director. We're actually in slightly different territory. We're not dealing with the question of whether the sheikh is liable for failing to do something. We're dealing with the question of whether he's liable for doing something. And it may make a difference because you may need a pattern of conduct to establish liability for failing to do something, and you don't need a pattern of conduct to establish liability for doing something.
Well, I would certainly respectfully concur with that, my lord. Yes, it's when one does something expressly holding out as a director, then there can't be any doubt about whether you've held yourself out as a director or not. Whereas if you're not doing something, then it may well be far more difficult to show whether that person has clothed themselves with the status of a director. I entirely agree. So we are in a far stronger position than they were, in fact, in Paycheck. The point I was endeavouring to draw out of that passage, and also the first few lines of paragraph 73, where they talk about executor de son torts, is that it's not about title. It is about intrusion, as Lord Collins puts it there, 2 lines up from the bottom of page 715. It's intrusion upon the affairs of the deceased in the case of an executor de son tort, and in the case of a de facto director, intrusion into the affairs of the company, I would submit. It's nothing to do with title. For a director, a de jure director doesn't take title. That's the very distinction that is at the heart of this. Perhaps I could take your lordship's back to Williams very briefly and just show you what Lord Newberger said about this in Williams, because it is a similar sort of point. Page 1032. Oh right, yes, it's at tab 48.
This is the paragraph 54.
Paragraph 54, yes. And Lord Newberger, in a concurring judgment, says that about trustees de son tort. If I could just invite your lordships to read 54. And although that does refer to money received under the colour of the trust, that is simply identifying implicitly the inevitable distinction between a traditional trustee and a company director. The point of principle, and indeed the editors of Lewin describe it as a principle, 4 lines up from the bottom of the extract. The principle is that a person who assumes an office ought not to be in any better position than if he were what he pretends. He is accountable as if he had the authority which has been assumed, and that is our case, really. For your lordships, note.
And you say he's accountable as if he had the authority which has been assumed. And in our case, it is a feature of what the Sheikh did, that he assumed and represented that he had executed the stock transfer forms at a time when the director of the company would have had the authority to do so.
Quite so, my lord. Yes, yes, and that in fact that plugs into a point that was emerged in exchanges between my lord and Mr. Crowe yesterday, which is I think where it got to is that Mr. Crowe's position was that an intermeddler who impersonates someone does not have liability if the person they're impersonating does not have the authority to do the thing that the intermeddler has purported to do, I think is where that got to. And we say that's that cannot be right simply rationally from a point of view of principle. The contortion at work is unsustainable. It's being said that the Sheikh had no liability because the liquidator had not authorised him to do the thing that he wrongly did, with the implication that had the Sheikh been authorised by the liquidator to exercise powers, he would have attracted fiduciary liability. And that's, if anything, the fact that he hadn't been authorised should be an aggravating factor rather than one that puts him in a better position.
Yeah, but the simple point is the authority which he purported to assume by backdating the documents was at a time when there was no limitation on the power of directors.
Well, precisely. That's a taking Mr. Crowe's position even on its own terms. Therefore, the Sheikh did impersonate someone who did have authority to do as he did, namely a director pre-liquidation. And a further sort of observation on that is that the whole point of an intermeddler type analysis is to prevent people misappropriating things. And where a fiduciary has authority to deal with company assets, a misappropriation by such a person is highly likely to involve them going well beyond their authority. So they will, even a fiduciary will be acting outside their actual authority when they misappropriate company assets. So one would never coherently say that a fiduciary has authority to misappropriate company property. That would simply make no sense. So that's what I should like to say about ground one, my lords. I'll move on now, unless there are any further points arising from ground one onto ground two.
Specifically on Mr. Crowe's point in relation to intermeddling, that all the authorities refer to having the property, you say the key distinction is that you're dealing with the company director, where the law works a bit differently. You don't actually have to have the property. The relationship is that which we've seen in the cases.
My lord, yes.
And the overriding policy is stated, I think it's in it's in Saw and Ashwell, I think, which isn't in the bundle, but it's that the law holds somebody who assumes the role of a fiduciary to the same duties and liabilities as if they were in fact, if they were in law a fiduciary, because that is what they have assumed to be.
In a nutshell, my lord, yes, exactly. So moving on now to ground two. We say that this case is outside the scope of the target and AIB cases. Those cases provide guidance to the court about the approach that it should take where a solicitor has negligently released completion funds without obtaining all the security that they should have done, but then takes steps post-breach to get that security in. In my submission, Target and AIB don't purport to lay down any binding rules about the approach to be taken where a dishonest fiduciary has misappropriated assets and taken no steps to make amends. and all those cases, all those two cases say, and indeed Canson, the Canadian case that influenced them, is that you don't ignore things that happened between breach and trust. Between breach and trial. They don't say or imply that in a case of misappropriation, the date on which the assets are valued is the date of trial, in the sense of you look at what the assets are worth at the date of trial. What they say is that the date of trial is when you evaluate the loss, taking into account, i.e. not ignoring things that have happened between breach and trial. There's certainly no bright line rule that the value of the assets at the date of trial is the value that the beneficiary is stuck with. We further say that the target and AIB approach is not appropriate for a situation where a company director has misappropriated company property. We say that that is clear from Bairstow and Queen's Moat, Auden Mackenzie and Patel, and most recently in Davis and Ford. This case is also nothing like Re-Ahmed. That was a case where non-fiduciary strangers to a trust delivered up the shares. I've been just pausing there. I have been criticised for talking in terms of delivery up of shares in the past, but that is the language that Lady Justice Gloucester uses in Re-Ahmed. That was a case where non-fiduciary strangers to the trust delivered up shares in advance of trial. And in that respect, Target, AIB and Re-Ahmed could all be seen as being of the same class, albeit very different facts. There was some kind of post-breach accounting by the defendant, either getting in the security to the maximum extent that was possible in the Target and AIB cases, or returning, delivering up, as Lady Justice Gloucester put it, the shares. The appellants submit that all equitable compensation is reparative and should be approached in the same way as common law damages. And if that's right, then on the facts of this case, at common law, the appropriate valuation point would have been the date of the misappropriation of the shares. And we say that that sort of cross-check, we accept that common law damages aren't at large here, but cross-check by reference to what would happen in a damages case shows that the Sheikh must be wrong in what he says about equitable compensation. For we say that a defrauded beneficiary cannot possibly be worse off as against their dishonest fiduciary than would a claimant in a claim for conversion. Further, on the facts as found at trial, the judge didn't decide that the shares were worthless, and the court, I think, already has this point from looking at paragraphs 557.3 at Core Bundle 255 and paragraphs 573 to 574 at Core Bundle page 260. And in fact, the judge was careful not to say that
Can we have a look at, speaking for myself, can we have a look at those, please,
Yes.
quite carefully?
Yes, my lord. Let's go there now.
Well,
So if
the other question on that
Yes.
is she says it was part of your case. Is she wrong about that?
we submitted at trial that it appeared that the shares were worthless as a consequence of the July 2017 dealing.
Right, and she says she accepted your case on that.
I'm not sure, my lord, respectfully, that she went quite as far as that. My reading of the judgment, and indeed the consequentials judgment, which I'll show your lordship in a moment, because that puts a bit more light on the judge's thinking on this. The judge was careful every time she referred to it to not make any firm conclusions. But for how could she? She knew nothing about it. She knew nothing more than the liquidators or this court about the terms of the 23rd of June 2017 transfer or the transfer of assets at the end of July 2017.
I mean, there are two possibilities. One is that the transfer of assets in 2017 was invalidly or unlawfully effected, so that the company would have, or although it would have lost its assets, it would have a claim to recover them, which, if you valued the claim, should mean that its value is the same before and after the unlawful disposition. I mean, in practical terms, it's lost its assets, but it should have the possibility of a claim. The other possibility is that it's a lawful disposition by the company of its assets, in which case, prior to the disposition it had value, and after the disposition it had no value. Those are the two possibilities,
Yes.
as I understand it.
Yes, my lord.
I mean, in practical terms, it's often right to talk about a company which has no assets as being valueless and to ignore the fact it might have a claim to recover them.
And I mean, this obviously is a point where it to have substance would potentially help you. It might be said, well, the defendants did nothing to help the judge to conclude that it was the latter rather than the former.
And that, my lord, is the approach that the judge took below. We say rightly. The judge said that because the sheikh was a fiduciary, the burden was on him if he wanted to make points about value to lead evidence in answer to our submission, which was that given the things that happened to the shares in June and July 2017, the safest valuation point was...
So the things that happened to the shares?
Yes, they were transferred from JJW Guernsey to MBI International Holdings on the 23rd of June 2017.
That wouldn't of itself diminish their value.
No, it wouldn't, but
It's the asset transfer.
It's the asset transfer at the end of July 2017. But as I understand it, the Sheikh's position was that there was the restructuring, as he put it, was they were all sort of connected transactions. But that's all we were told.
I mean, as I've said to Mr. Crowe, it is very, very odd on the face of it. An 11% holding pre the transfer was apparently worth, I can't remember what, $70 million. Therefore, the total net asset value, assuming it was valued on a net asset basis, would be worth $700 million. And we're told it's then worth nothing.
Yes, remarkable, isn't it? Yes, I dissent from none of that. We've scratched our heads about it as well, my lord. And the approach that the learned judge below took, we say rightly, was that if the sheikh wanted to rely on diminution in value, then he had to lead evidence on that, and he didn't. How, I ask rhetorically, could we as liquidators possibly have answered any of those points? The sheikh's case is essentially that he can absorb the assets, the shares, one way or another into his empire, which is what appears to have happened, and then he can just say no, just prove that they're worth nothing, or
No.
that they're worth something.
And it might be said against you, well, that was your choice. You told the judge you didn't want to proceed to the taking of an account or the like. You make do with the evidence that there was.
Yes, we did make do with the evidence that there was, and the evidence that there was the JJW Inc. accounts for the year ended 31st of December 2016, which were signed off, I think, mid-May 2017, so very shortly before this so-called restructuring took place. That was the evidence that we invited the judge. I should say that was our secondary position, because the primary position was that the judge should look at the statement of affairs. But the judge took the appropriate valuation point as the 2016 accounts. I think on the footing that was sort of halfway between the shares being transferred to JJW Guernsey and the so-called restructuring in July 2017. And so one had a safe valuation because this was the Sheikh's own document, and one could apply the same sort of pro rata valuation that he himself had applied in the statement of affairs, and there wasn't any other safe evidence to go on.
Well, I don't understand that, because what the judge says in paragraph 557 is she says the liquidators identified 3 pieces of evidence on which they rely as disclosing the value of those shares at different times, and you've confirmed that this is accurate. And the third one is 27th of July 27th resolution, pursuant to which all of JJW's assets were transferred to JJW UK, such that as at time of the transfer, JJW shares must have been worthless. So, as you confirmed, it was part of your case that following the asset transfer at the end of July 2017, the shares were worthless.
I think the missing component from that, my lord, is well, two things. Firstly, the judge has recorded there at the time of transfer as our submission at trial, and I'll come on to why that's relevant in just a moment. I think the missing component of that submission is that was a submission that, therefore, given that the Sheikh has been, or would appear to have been in control of this restructuring, therefore the safest point of valuation was either the statement of affairs or the 2016 accounts. We certainly weren't submitting that the shares are worthless, therefore we should get an award of nothing, because our submission before the judge, as it is before your lordships, as I summarised a few moments ago, is that the law is not that the court must take the value of the asset at the date of trial. One assesses the loss at the date of trial, not ignoring things that have happened between breach and trial. But that certainly doesn't mean that the court's hands are tied. For otherwise,
why then does the judge say in 574? I mean, not only does she accept your case on limb 3, but she also goes on to say that the relevant date is the date of judgment.
That's the date when one makes the assessment, my lord. I mean, as my Lord Justice Snowden observed yesterday, if it were the case that a director could misappropriate assets and then denude them of value, all they would need that's a formula for avoidance. And if I might show your lordship how the Sheikh put his case below, which will put a bit of context around that subparagraph 3, and in particular the reference to as at the time of the transfer. If I could show your lordship supplemental bundle, page 141, please.
Beg your pardon, could you give me the tab?
I think it's 24.
Thank you.
Assuming I've gone to the right page myself.
It should be page 141, my
Yes.
lords. This is an extract from day 19 of the trial closing submissions. Page 35, top right there. There's an exchange about the value of the shares, and there's an exchange between the judge and Miss Stanley Casey, and a short intervention from me at line 14 where I correct worthless to has no assets, and Miss Stanley accepts that. That was my incorrect reading to the words, has no assets, worthless. And then Ms. Stanley does not accept that. She says at line 20, no admissions on that. Sorry, the learned judge says no admissions. And then Ms. Stanley says, correct, so the burden is on the liquidator to prove this, i.e. that the shares, that the company has no assets. See Re Ahmed. And Ms. Stanley continues, it doesn't follow, we submit, in case it's alleged, that because JJW Inc. transferred the assets it had in July 2017, that it doesn't have assets 5 years later.
Well, exactly.
So,
this is what's puzzling me, is that the parties seem to reverse their positions from where they were in the lower court. Because, as you've just shown us, in the lower court, the Sheikh was denying your case that they were worthless, and now it's the other way around.
the position, my position in the lower
judge
court,
having found in your favour.
my position in the lower, well, my lord, I wasn't running in the lower court. I wasn't running an argument that the shares are worthless, therefore we should get an award of nothing. The submission that I endeavoured to make in the lower court was that if the Sheikh's position is accurate, then he has disposed of the assets of the company. Therefore, the appropriate point of valuation is the safe points that we have before all these things are alleged to have happened that the Sheikh has told us really nothing about at all. Namely, the statement of affairs, 132 million, or the 2016 accounts, which comes to about 67 million. And the learned judge accepted the second of those positions, namely use the 2016 accounts.
I mean, the difficulty with all this is that there just doesn't seem to be, with great respect to those who are involved, I mean, and there may be reasons for this, enough sort of focus on the actual detail. You say because you didn't have it, well, it wasn't offered. But as I said, there are three possibilities. One is there's an entirely lawful disposal of assets by the company, which could have been done in any event. Secondly, there's a lawful disposal of assets which could only have been done because 100% of the shares were vested in the same person who approved it, if that in fact is the law query. And then thirdly, there's a completely unlawful disposal of assets, which just as a matter of practicality happened within what I'd call the overall Sheikh empire, in circumstances where the company may be denuded of assets, but might, if there were to be an independent person back in control, be a cause of action that could be vindicated.
Yes. Well,
and those are three possibilities. There may be more. Those are three that occur to me, but nobody seems to have really drilled down into those. And this exchange you just pointed us to, talking about or equating a situation of no assets with being worthless ignores the point about, for example, whether there's actually a cause of action to get the assets back.
yes. Well, it's not for us to identify causes of action vested in JJW Inc. I would respectfully submit that there is certainly a lack of detail on what happened in June and July 2017, but I would respectfully dissent from the suggestion that there was a lack of focus on that, my lords. We worked very hard from 2016 onwards to try to focus in on the detail of what the Sheikh had done. And if were this appeal listed for a week, I would like to... yeah, sorry, my lord.
Yeah, I'm sorry to interrupt, but I mean, I appreciate the point you're making. But to come back to what you were saying a moment ago, I mean, I can understand that now, at any rate, you seem to be making the submission that actually none of this matters, because you made what I thought was a clear submission to say, as a matter of law, the correct date for valuing the misappropriated assets is the date of breach in the circumstances of this case. Because you say this is a different sort of case to cases like Target AIB. Now, if you're right, that as a matter of law, in a case such as this, the correct date for valuing the misappropriated assets is the date of breach, then we can forget about what happened later. But am I right in understanding that that's where you pin your colours to the mast?
Yes, my lord. The judge was right below to say...
Well, I'm not sure that's what she did. I mean, it may have been the effect of what she did. I don't think that's her reasoning, but that's another matter.
My lord, my understanding of the judge's judgment is that she accepted our submissions on substitutive performance measure of equitable compensation, which I will come on to. That being the case, the appropriate point of valuation was the date of breach. And the judge, although the judge took a value from the 2016 accounts, my understanding was not that the judge was saying that's the right date evaluation. She was saying that's the safest evidence that we have in order to give effect to a substitutive performance measure of equitable compensation. So it's a point of principle, namely...
Remind me what you mean by substantive performance there. Can you remind me what you mean by substantive performance? Rather than just using the label, can you unpack it for me?
Yes, by all means. I'll do it by reference to authority, if I may, my lord.
What it comes to, as I understand it, in terms of this case, is the judge, on the basis of your submissions, said, I mean, she gave various reasons for her decision, but one reason was we don't have to consider what a counterfactual would have been.
Yes.
And that's essentially what you're trying to suggest.
Yes, my lord. Yes. Yes, but my lord, the
Well, you go further than that, don't you? Because it's because Mr. Crowe emphasises that his case is not of a counterfactual. He's relying upon what actually happened. But you say what actually happened subsequently is irrelevant.
yes, I say what happened subsequently is irrelevant. As a part of that, I say you don't get to run the counterfactual as a defendant fiduciary. And in my respectful submission, great respect to my
Why is it a counterfactual? I don't understand why you called it a counterfactual, because it's what actually happened that Mr. Crowe is relying on.
It's a counterfactual when you compare what actually happened with what would have happened but for the breach. That's the relevant counterfactual. The counterfactual world is the world in which the breach didn't take place, and so one has to value the position as it was in the world that happened, namely the world where the Sheikh dishonestly breached his fiduciary duty, compared with the counterfactual world where the Sheikh didn't. And in fact...
But is there any reason to believe that the transfer of assets wouldn't have happened if he hadn't breached his fiduciary duty?
We don't know, because the Sheikh's the Sheikh hasn't said anything about that.
Save that, just applying normal principles, the only conceivable basis on which a company can normally give away its assets is if it's 100% of its shareholders agree to that.
Yes.
But
right.
since actually, even though you didn't know it, you held 129,000 shares, it was impossible for all the members to agree. So that can't be the basis on which the Sheikh made his decision.
Yes. Well, I don't dissent from any of this, my lord, and these are questions for the Sheikh, really, I would suggest.
But that suggests that even supposing that the Sheikh hadn't got the shares registered in the name of JJW Guernsey, there's no particular reason to believe that the transfer of assets wouldn't have happened anyway. He wasn't deterred by the fact that 129,000 shares were vested in you. Why would he have been deterred by the fact that a larger number of shares was vested in you?
This is counterfactual speculation, my lord. This very exercise now. Why wouldn't that have happened but for the breach? Well, we don't know.
But does it, to pick up what Justice Arnold said a little while ago, but put it slightly in a different way, does this come down to the question where we look at the authorities on whom the burden rests of demonstrating that, I think what Lord Reid called the interruption of what Lord Reid calls, effectively referred to as the interruption of the process of causation.
Chain of causation.
Yeah, I mean, he didn't use the word chain, he used a slightly different expression. It's the question of on whom the burden lies.
Well, precisely.
I mean, if your primary submission is right, although I'm not quite clear how it fits, none of this matters. But if it did, it would be for the defendant to say it does matter. You do have to look at what happened subsequently, because it's only when you look at what happened subsequently you can see that a particular loss was not caused by my breach.
Yes, I mean it's a.
And you say that the burden is on the delinquent fiduciary, especially in the case of dishonesty, to say, if they want to say, look, that loss that you attribute to my breach was not caused by my breach. It's for them to say, whereas they say, no, it's for you. You've got to identify the loss which you say was caused, and if the court at trial can see that in what I might call the ordinary course of events, the asset would have diminished in value of its own accord, you can't lay that at the law of the delinquent fiduciary. So there's a question of burden.
Can I, before you respond to my lord, add two things from the judgment on that. The first of them is paragraph 567, where the judge says, insofar as the MBI respondents seek to advance the case based on the counterfactual and or an intervening act, the onus lies on them. So that's my lord's onus point. In terms of the dishonesty point, the judge has said in 5552, I accept the submission that a finding of dishonesty doesn't affect the approach to compensation.
Yes, the point in Sorry, my lord. Did your lordship say 552?
555 sub 2. She accepts that dishonesty doesn't affect things.
Yes, the context of that is that it's a remark made in AIB. In Target. No, AIB. I can't remember. It's one of the two. That cases of dishonesty cases of fraud might be different.
Yes.
We don't, on this appeal, submit that. We haven't appealed the judge's conclusion of law on that. But what we do say, and this is what I hope to be able to unpack from the authorities, if time permits,
Yes.
is that one has to look very closely at the context of what the fiduciary is doing and what they're supposed to be doing, so what they do compared with what they're supposed to do, in order to work out what the consequences should be. So the context of a dishonest misappropriation of assets, which are then not followed up by any sort of accounting at all, are in a very, very different category. And this really goes back to the very first point I made on ground 2. In a very, very different category from Target AIB and Riame. So if I could move on,
Yes.
my lords, to Target and AIB, I'm going to take these decisions very much quicker than I had hoped to, but your lordships will be well aware, I'm sure, that Target and AIB were both cases about unauthorised ways of carrying out an authorised transaction. In both cases, it was a one-off conveyancing transaction. And the gist of both cases is that the trustee, in each case, was only liable for losses caused by the unauthorised aspect of the transaction, not losses that were inherent in the deal that would have happened and played out if the transaction had happened in the authorised way. And so, as I've already said, they're authority for the unremarkable proposition that you don't ignore things that have happened between breach and trial in working out what the actual loss is. Now, in both cases, shortly after the breach, the trustee, who was a conveyancing solicitor, got in all the security that they could. In Target, the lender got all the security that they'd bargained for, and in AIB, they got a second charge sitting behind a relatively small first charge, when they had expected to get a first charge. Now, there's two critical distinctions between both cases and this case. Firstly, in both Target and AIB, there was a consensual bargain for transaction that was capable of proper completion. And there had been post-breach steps to get in that the asset that the fiduciary should have got, but for the breach. If we could go, please, to page 358, and this is tab 23, my lords. 358 in the authorities bundle. This is from Target, and your lordships may remember looking at this page yesterday. And between letters C and D, my learned friend yesterday showed your lordships the following sentence. But the basic equitable principle applicable to breach of trust is that the beneficiary is entitled to be compensated.
Could you give me the page again?
Oh, I'm so sorry, my lord. Page 358.
Sorry. Yep.
So the sentence that your lordships were shown by my learned friend yesterday is between C and D, and it is this. But the basic equitable principle applicable to breach of trust is that the beneficiary is entitled to be compensated for any loss he would not have suffered but for the breach. Now, I would respectfully invite your lordships to read on, because the next sentence makes clear the limits of what Target is really about. Lord Brown-Wilkinson goes on to say, I have no doubt that until the underlying commercial transaction has been completed, the solicitor, the trustee, can be required to restore to client account monies wrongly paid away. But to import into such trust an obligation to restore the trust fund once the transaction has been completed would be entirely artificial. So, firstly, there's a commercial transaction, a consensual one, that is capable of completion. So there's something bargained for that the beneficiary expects to get. And until completion, the trustee can be required to restore the monies wrongly paid away. Well, in this case, not only is there no commercial transaction capable of playing out, but the assets haven't been restored, and the court has to do the best it can with the evidence it's got to value the asset lost. And in my respectful submission, that's what the learned judge did below precisely. One other passage I should like to show your lordships from that case, if your lordships would care to turn to page 362. Between A and B, Lord Brown Wilkinson, I should say that this was an application for summary judgment by the lender for the entire amount paid away in breach of trust, giving credit only for the recoveries that were made on the security. Lord Brown Wilkinson says, in my judgment, these remarks provide no basis for holding that final judgment can be given when, on the facts known at the date of trial, the plaintiff has eventually suffered no loss. But on the facts known at the date of, sorry, it says date of judgment, forgive me, I said trial. On the date of judgment, the plaintiff has eventually suffered no loss. But on the date of judgment in this case, that couldn't be said, because the fact we'd had a trial and the judge had reached findings that were to the effect that we simply didn't know what the position was in terms of the value of the shares at the date of judgment. And that's if we're in target territory at all, which I say we're not. And then the final passage I should like to show you, lordships, is by letter G. Lord Brown Wilkinson says, for these reasons I reach the conclusion that on the fact which must currently be assumed, for this was summary judgment, Target has not demonstrated that it is entitled to any compensation for breach of trust, assuming that monies would have been forthcoming from some other source to complete the purchase from Mirage, if the monies had not been wrongly provided by Redfern's, as a solicitor, in breach of trust. Target obtained exactly what it would have obtained had no breach occurred, i.e. a valid security for the sum advanced. Therefore, on the assumption made, Target has suffered no compensatable loss. Redfern are entitled to leave to defend the breach of trust claim. Now, that is a very far removed from the instant facts. Where,
so in other words, you can't escape from the bad bargain which you wanted your solicitor to facilitate.
Exactly.
By the happenstance that your solicitor has breached trust by paying away money ahead of time.
Yes.
And if at the trial it can be seen that you got what you bargained for, you can't lay the economic consequences of your bad deal at the door of the solicitor.
That's right. I mean, it would have been pretty outrageous if the solicitor had succeeded on Target and, sorry, if the lender had succeeded in Target and AIB, because it would have meant an enormous windfall to the lender in both cases. They would have got back the entire amount that was dispersed by way of loan, giving credit only for the inadequate security that was got in, and it would have essentially been insuring against the bad bargain by the chancy feature that the solicitor happened to release the money from client account too early.
And of course, it might be said that this judgment gives you a windfall because, so be it, you had shares worth an awful lot of money. But had there been no misappropriation of those shares, you would have held them, they would have lost all their value, and you would have ended up with nothing.
One could say that, but that is running counterfactuals, that all this would have happened in the counterfactual world where there was no breach, and there simply isn't evidence to support that. And it's not for us to disprove what would have happened. It's for the Sheikh to lead evidence if he if he wants to.
Well,
But
it's
he hasn't.
It's disprove what, as my Lord Justice Arnold put to you a little while ago. It's not a counterfactual. It's what has happened. There has been a disposition of assets by the subject company. I can't remember what it's called now.
JJW Inc.
JJW Limited. That's right. So I've lost my chart. Sorry. Without which I feel sort of naked and unable to communicate coherently. That has happened. It's not a counterfactual. It's actually a question of where the burden of explaining that transaction lies. If you say it should be ignored, then the question is it for you? You know, do you have to demonstrate to the court it should be ignored? Yeah. And if Mr. Crowe wants it taken into account, is the burden on him to explain it and explain why it would have happened in any event?
Yes.
That's what seems to me at the moment is the unanswered question that I'm searching for an answer for.
Well, primary position is you ignore it because in a substitutive case you value the shares.
Yeah, well, you need to explain what you mean by
yes,
a substitutive
well,
case.
I would
don't use the label.
I would like to. Yes. That's the primary position, and the secondary position, to the extent you look at it at all, the burden is on the sheikh to explain what happened with this transaction. It's a basic principle of fiduciary liability is the burden is on the defaulting fiduciary.
Well, I know what the positions of the parties are, but it's a question of fitting them within the authorities. I think that's for me anyway, speaking entirely for myself.
So last observation on target. Mr. Crowe's criticism of Warden Mackenzie was that it was summary judgment where the defendant was given leave to defend, and so he seemed to suggest that the limited weight should be given to the reasoning. Well, the target was exactly the same. So to the extent Warden Mackenzie is tainted, so too is target. AIB, the principle is essentially the same as target on simpler facts, because there was no allegation there was no untried allegation of fraud at large, which there was in target. I won't go through it in any detail in the interest of time, but the passage that I would respectfully invite your lordships to read.
Sorry, just wait, sorry. Slow down. Sorry, on tab.
It's 51.
Okay, thank you, my lord. I wasn't, in fact, planning to, in the interest of time, I'm not planning to take your lordships to AIB in any detail. Well, the passage that I would invite your lordships to read. Well, let's go there. Page 1140. If I could respectfully invite your lordships to read paragraphs 70 and 71, please. Yes, thank you, my lords. The points I would draw out from paragraphs 70 and 71. This is a case about commercial trusts, as target was, a consensual bargain playing out. By letter A on page 1141, the scope and purpose of the trust may have a bearing on relief, and that goes back to the point I made a few minutes ago, that you have to look at what was done compared with what the trustee was supposed to do, or the fiduciary was supposed to do. By B and C, Lord Toulson says solicitors should not be required to pay restitutive compensation where there has in fact been no loss resulting from their breach. And when he uses the word restitutive, he is referring to what is called substitutive performance in the cases, which I'm going to come on to in just a moment. Critically, by D and E, what's key is that the fact that the trust was part of the machinery for the performance of a contract is a relevant fact in looking at what loss the bank suffered by reason of the breach of trust, because it would be artificial and unreal to look at the trust in isolation from the obligations for which it was brought into being. Now, my lords, this is very far removed from the incident case, and in my submission, target and AIB are simply not about the sort of situations that of which the incident case is one. We'll move on now to Re-Ahmed. Re-Ahmed has assumed a prominence on appeal that it didn't have below. It's a bankruptcy case, and the facts are unusual and very different from this one. And I'll just briefly summarise the facts. There was a bankruptcy petition on 23rd of January 2007. Assets were transferred by the debtor to the first respondent on the 6th of June 2007. There was then a long gap, 2-year gap, before assets were transferred by the first respondent to the second to fourth respondent between 2008 and the 30th of June 2009. The bankruptcy order was made on the 21st of April 2009. The trustee was appointed on the 22nd of July 2009. The assets were returned by the second to fourth respondents to the first respondent on the 30th of June 2010. And then there was delivery up of the assets, which were shares, to the trustee in bankruptcy on the 27th of February 2015. And then a trial took place in March 2015. The transfers were only contingently improper at the time they were made, because they didn't become void until the making of the bankruptcy order. Now, the most significant point of distinction, I submit, is that as in Target and AIB, there had been a belated accounting. The shares were delivered up, as Lady Justice Gloucester put it, to the trustees in bankruptcy. So accordingly, there was always going to be a complicated counterfactual exercise to work out how to value the loss to the estate as a consequence of being temporarily deprived of the asset. The court held that the loss had been caused between a 3 to 6 month window after the appointment of replacement trustees in bankruptcy on the 14th of April 2010, and the valuation date was struck at 30th of June 2010. Now, that conclusion was reached on the evidence, just as the judge's conclusion in this case that Ms. Caulfield would have sold the shares, which is a finding that the judge made, was reached on the evidence at trial in this case. Now, that finding by the judge is a finding of fact, and although Mr. Crowe is right that strictly speaking it's obiter, because the judge in fact held that a substitutive performance measure was appropriate, which meant that you didn't need to get this far, she held that even if she was wrong about that, Miss Caulfield would have sold the shares had it been open to her to do so. Now, Mr. Chris, the current liquidator, he was in the box for the whole of days 2 and 3 of the trial. It was an exceptionally long spell in the box for an office holder, and his cross-examination was by far the longest of the trial. The evidence which the judge accepted was that Mr. Chris was supervising Miss Caulfield. Mr. Chris is the principal of the firm concerned, was supervising Miss Caulfield during Miss Caulfield's time as liquidator, so he could speak to the whole period when Miss Caulfield had been liquidator. Further, the judge drew no inferences from Miss Caulfield's non-appearance at trial, which was explained by Mr. Chris as simply being that Miss Caulfield no longer worked at the firm and he was the liquidator. And there was a very strong evidential basis for the judge to conclude that Miss Caulfield would have realised the shares had it been open to her to do so. Now, the Sheikh, in answer to that, and in order to challenge that finding of fact, which they must challenge in order to succeed, is that the judge shouldn't have predicated her finding or conditioned her finding on if it had been open to Miss Caulfield to do so, because the judge shouldn't have assumed a perfect world where the Sheikh cooperated, but should have assumed that the Sheikh would endeavour to frustrate the realisation of the shares. That's my paraphrase. That's not quite how they not the words they used, but that's the gist of it. The stonewalling is the word that Mr. Crowe used. But that's an enormous counterfactual speculation. What the Sheikh would have done, but for the breach, if he had been acting sufficiently properly not to misappropriate the shares, but was pursuing some other strategy, there's simply no evidential basis for that speculation at all. And in any event, the Sheikh doesn't get to run that counterfactual. The
So
evidence.
just pausing there. You're running the counterfactual that had you kept the shares, you'd have set about selling them. You say the Sheikh can't run the counterfactual that he would have made life difficult for you.
Yes. Well, if I could slightly nuance that, my lord, we say we don't need to run any counterfactual at all because the loss was occasioned by the misappropriation of the shares, and that's the appropriate point of valuation, and the court has to do the best it can with the evidence it's got. If we are required to run a counterfactual, then we would have realised the shares.
I know you're going to come back to this. On the face of it, cases like Target and AIB are not really dealing with data valuation. On one view, substituted performance means that you get the value of the shares. Well, the value of the shares, we're told, is nothing. So substituted performance doesn't obviously help you because you get nothing. Your point is you should adopt a different data valuation, and it's not obvious to me that the authorities are really dealing with that.
The authorities don't tie the court's hands as to any particular date of valuation. Even Target and AIB, simply all they say is that you don't ignore facts that are known to have happened between the data breach and the date of trial.
Yeah. I mean, that's because in Target, I think it was, there was a argument being run by the bank, I think, that the clock had to be stopped, became the expression. As soon as the funds had been paid away in breach of trust, and therefore you had to say that the money paid away had to be restored, irrespective of what subsequently happened, namely that the bank got what it bargained for, and the House of Lords rejected the stopping the clock approach.
Yes. Exactly. Yes, and that's all Target, AIB, and Canson are really saying is that you don't ignore things that happen between breach and trial.
Well, I understand that, but is that an answer to the point? Would you accept that the primary remedy of a beneficiary where assets have been misappropriated is to have the assets restored. So in the present case, the shares have been misappropriated. Your primary remedy, if it were possible, would be to have them restored to you. Yes?
Yes.
And if they were worth nothing, that would be valueless.
Well, I'm not going to speculate now on what sort of other claims might be available to the liquidators in those sort of circumstances where the shares have been away from the company for just over 8 years now. But it's clear from my learned friend submissions yesterday that isn't going to happen. So one then gets into the question of valuation, and I accept my Lord Justice Newey's observation that the question of loss is not necessarily the same as the question of valuation. And so what the court...
Well, to be sure, but it goes to the question of that you raise as to what the proper date of valuation is. And if the primary remedy is restoration of the asset, and if it could be returned to you, you will get it at trial, why is not the right date of valuation trial? Judgment.
There's no evidence of value as at that date. What we have is the court has to do the best it can with the evidence it's got, and the best evidence that the judge found was the 2016 accounts. And if the shape wants...
But that's a different point. I completely take your point. The court has to do the best it can with the evidence it's got. Fine. But you're raising a point of principle as to the date of valuation, which is a different point, surely.
My submission, my lord, is that what we lost was 891,000 shares in March 2016, and the appropriate valuation point is the point of breach. Because that is the measure of, that's the proper measure of our loss. If one applies the authorities that I'll now have to come back to, I think at 2 o'clock, on the substituted performance measure.
And you obviously will have to, but I have to say it isn't obvious to me that they really help on this. And targeted AIB don't seem to deal with data valuation. Orden Mackenzie isn't concerned with data valuation either. It's concerned with, I mean, everybody knew what the asset was worth. It was cash. It was a question of whether you could take into account what might have happened to the cash, which is a different thing.
In the interest of time, most efficient use of, I will think about that point over the short adjournment.
Why? Just in case you didn't have enough to do. If I don't know what you've got open in front of you, whether it's AIB or if that's something else, isn't it? But in AIB, I'm looking here at Lord Reed's judgment. So this is tab 51, page 1145. Lord Reed refers to the decisions in Caffrey and Derby and Canson, which particularly I think Mr. Crowe referred us to, certainly Canson. And at paragraphs 88 and 89, he draws a distinction between those two cases, which he subsequently comes back to in paragraph 135 of his judgment. And I'll come to that in a moment, because that picks up the point my Lord's just made to you, I think. But just looking at them at the moment, there's a passage from the judgment of Mrs. Justice McLachlan in Canson, which was said to be good law by Lord Brown Wilkinson in Target. And I'll just invite you to read that paragraph for a moment. it's 88 and 89, and if you've read that, then Lord Reed picks it up in paragraph 135 of his judgment, and I just will read that out. He says, the measure of compensation should therefore normally be assessed at the date of trial with the benefit of hindsight. The foreseeability of loss is generally irrelevant, but the loss must be caused by the breach of trust in the sense that it must flow directly from it. Losses resulting from unreasonable behaviour on the part of the claimant will be adjudged to flow from that behaviour and not from the breach. And then he says, the requirement that loss should flow directly from the breach is also the key to determining whether causation has been interrupted by the acts of third parties. The point is illustrated by the contrast between Caffrey and Derby, where the trustee's neglect enabled a third party to default on payments due to the trust, and Canson Enterprises, where the wrongful conduct by the third parties occurred after the plaintiff had taken control of the property and was unrelated to the defendant's earlier breach of fiduciary duty. Now, what he appears to be saying to me at the moment is that if we're looking at the measure of equitable compensation, it is a test of causation in a common sense way, using the benefit of hindsight at the date of trial. And there's a distinction to be drawn between a loss which would have occurred in any event, which was unrelated to the breach of fiduciary duty, would have occurred in any event, which is what Canson Enterprises was. Or alternatively, Caffrey and Derby, where it was only because of the breach of duty that a third party was able to, in that case, refuse to pay money that was owed. Now, does that guidance apply in the instant case? And if so, how do we apply it, is my question, in circumstances where Mr. Crow's point is that what happened in 2017 would have happened anyway, or at least there's no evidence it wouldn't, and therefore it's to be treated as a sort of Canson and Enterprises case, which is why he stressed it to us, I think. Or is it a Caffrey and Derby type situation where if the shares have not been transferred in the way that they were in breach of duty, that being the hypothesis for this, the denuding them of all value wouldn't have occurred. And if that is where we are in the instant case, I come back to that same point I made before, who bears the burden? Since if we're talking about what we get from AIB and Target, it seems to me that those are the questions that certainly for myself I would like to have some sort of idea of where I find the answers to or answers to.
Very good, my lord. Thank you. I will reflect on that over the short moment. I wonder if it's 5 to the hour, but I wonder if that's a convenient moment and perhaps come back.
Just in terms of where we are, I know you've had a lot of interruptions. Should we be coming back at 5 to, or will 2 o'clock do?
My lord, 2 o'clock will do.
We'll do that.